May it please the court, my name is Kevin Peters, and I represent 8 professors from Tufts University who were granted tenure decades ago. They filed a suit challenging the legality, contractual legality of compensation plans and a lab allocation plan, claiming that they were violations not only of their tenure contracts as they were formed at the time of their award, but also a violation of principles guaranteed by tenure, which include academic freedom and financial security. The action was dismissed on summary judgment. We're here appealing that decision. In its simplest form, this case really presents 2 questions. First question is whether Tufts was within its rights to impose fundraising obligations on appellants, all without their consent. The second question is, if so, if they're entitled to unilaterally modify an employment contract, then whether the modifications impinge concepts that are defined in the academic freedom and tenure policy, the after policy that the court will read or has, because it impedes academic freedom and financial security. Tenure in Massachusetts, as this court has said on multiple occasions, is contract.
Why do you take the position that academic freedom and what was the other? Economic security are not ambiguous terms?
2 reasons. Number 1, the parties understand what academic freedom means. In other words,
they dispute it.
No, my brother disputes it. Okay, but when I ask,
Represents a party.
When I ask, Your Honor, at academic freedom is defined as absolute freedom to pursue whatever your research interests are. There's no real debate at all what academic freedom means.
Well, there's no debate here that they were allowed to pursue it. The question is the consequences of it, right?
Well, no, Your Honor, they weren't, because the question is whether or not
No one prevented them from doing any research they wanted to do. They prevented them if they didn't generate income to pay for their lab space and everything else, what the consequences were, right? They could study, whatever they felt like.
The impact, even slight on academic freedom, violates the policy, and the impact's undeniable, and here's why. NIH, if it were only the case, and I would still claim that this is not a right they have to unilaterally modify the contract, but let's take the case, if it was only the case that they said, you must support half of your salary with research. I have professors that do that. Mm-hmm. They choose what they want to research, they study it, they write about it, and they make changes in the world. The problem is when you put the 65% ICR piece in, you've narrowed the field of available research. If you take research, every available source of research and funding for that research, including private research, this is a different argument in a different case.
I'm just confused what you're arguing, though. Are you saying that when those professors were granted tenure, many of them 30 or 40 years ago,
yes,
they can't change their lab space ever? They can't adjust their compensation in any negative way?
No, that's not what I'm saying.
What are you saying?
I'm saying that economic security and academic freedom are inextricably interlinked.
I understand they're interrelated. The question, though, is the language in the tenure principles talks about sufficient, right? It doesn't just talk about it doesn't say you can't lower anyone's salary, right?
No, and we don't argue that salaries can't be lowered. What we argue, Your Honor, is salaries cannot be lowered as a means to impose discipline on an academic who doesn't pursue research that is fundable by the NIH. I'll give you an example, Judge.
But if a pharmaceutical company was willing to pay the overhead, that's perfectly fine, right? If Wortis or one of these other major pharmaceutical companies was going to give them grants that covered that amount, no problem, right?
If it's 65%, it's no problem, Your Honor. The real question is a basic principle question. I think it's undeniable that if we take all the research that can be done in the world, Judah Folkman, anti-angiogenesis, for example, the COVID vaccine, if we take all the research that can be done in the world and we say you can only do that research, which has a 65% ICR return, then you're narrowing the field of available research. as a very practical matter in this context, given the competitiveness of trying to get these 65% grants.
But again,
Yes, sir.
they're running a university with a confined amount of lab space too. If you're occupying that lab space, someone else is not occupying that lab space, right? There's not an unlimited amount of lab space in Tufts. That's one of the reasons they're shrinking your lab space if you don't have grants to support it, because somebody else may, right?
The problem with the analysis, Your Honor, is that if you're using lab space as a cudgel to enforce the obligation to fundraise, which is what's going on here, and specific fundraising, 65% ICR, then what you're doing is you're using what is a right of the professor. I mean, this court addressed this issue in Halaki versus Stewart Healthcare. A professor has.
I know, but we're here because tenure is, this is not, I mean, there are thousands of professors in Massachusetts with tenure. And we're trying to understand and those principles appear in at least some background way in every single tenure case, right? So
Yes,
we're
sir.
trying to understand what meaning they have and how specific those requirements are, right?
But let me go to first principles then.
Yeah, okay, that would be helpful, because I can't figure out from your brief seems to be an absolute brief, that shrinking their lab space, diminishing their salary in any respect is a violation of tenure. At least that's the way I read it. I may be misreading it, but what are they allowed to do consistent with those
Let
principles?
me let me try to make this clear.
Mhm.
I'm defending from the smallest space I can stand on. I am saying these policies, all right, the 2017 policy is modified in 2019, imposes an obligation that did not exist at the time they were granted tenure. Tufts' position is that they can do that. Why? Because they maintain the right in the handbook to change personnel policies. So what Tufts does, if we want to talk about ambiguity, and I think we must, is they take the term and they define it their own way. They say personnel policies means I can put a policy in place that even though I have a contract with the professor that is full-time, for life, that cannot be revoked except for
So you
malfeasance.
say that's what it says. It doesn't, that's not what their tenure letters said. Their tenure letters, in order to get tenure, they had to be full-time. And to get tenure is a big deal. You win the trifecta, right? The trifecta is you have some continuous employment, you have some economic security, that's sufficient economic security, and you have academic freedom. That's the trifecta. That's why they pop the champagne bottles when you get tenure, right?
Or sue when they don't.
But I don't understand, there are limits to that too, right? And
Limits have to be contractual. I think we have to agree to that because tenure is contractual. So the question is, what was the right when initially granted, and whether or not the university,
so what
which I can
what
transpose.
they do with again, these are, your clients have been employed for 50 years, some of them. Some of them, their grants have almost completely disappeared. What can they do consistent with those tenure principles? Nothing, or
No.
have they gone too far? They may have gone too far, but they must be able to do something, right?
Yes. And I
those
think that
principles, as Justice Wendland's pointed out, are somewhat ambiguous.
So what they do is they take a concept, and the concept is personnel policy, and they morph that personnel policy into we can do whatever we please.
But
Okay?
that's not, so can you answer this question? What can they do consistent
Yes.
with your view of their contractual obligations to your clients?
If a professor is not seriously performing his or her obligations, they may be referred for tenure revocation pursuant to a tenure revocation policy that gives the professors.
Where is that coming from?
The tenure revocation policy is under.
No, not the tenure revocation policy. The analysis as to what flexibility Tufts Medical School has in light of the tenure contracts. Doesn't that come from norms in the industry, or where is it that
Yes.
you're finding? Yes.
Norms in the industry is a good place to start, Your Honor.
Okay, and we only look to those under our canons of construction of a contract if the terms are ambiguous, which is why I started my questions with, are these terms ambiguous? And I was surprised to hear you say no, because if they're not ambiguous, we don't look at the norms of the industry.
There's two things. We have a situation where I think neither of us necessarily thinks the terms are ambiguous. I think maybe he thinks they're unenforceable, but we know what academic freedom is. And we know what the norms in the industry are. The American Association of University Professors submitted an amicus on it. It's
Okay, so
very
they
thick.
have to be ambiguous in order for me to look at the norms in the industry.
Let's assume that academic freedom is ambiguous.
Or the
Like,
combination of that with economic security.
is ambiguous, then the question is you look to the industry itself.
And this is on summary judgment. What is in the record about the industry norms?
we have 4 or 5 expert affidavits that we submitted that discuss this very issue that are in the record.
Okay.
But don't both
3 or
of you
4.
agree that the AAUP, those principles are the norms in the industry? What they actually mean, you differ on, the DC Circuit opinions, at least some of the amicus refer to, talk about those norms, that they're sort of the key norms in the industry.
Right.
Because academia is not really, although it's become more of an industry, at least when some of these people were given tenure, it's a different era, but those are the norms, right?
Right. And
how restrictive they are is what I find ambiguous and unclear.
except that, Your Honor, if we take the very basic principle, and that is academic.
But I don't see how it gets you there. Sufficiently economic so that people of real intelligence stay in the profession. Your clients prove that.
No.
They stayed at Tufts for 30 and 40 years. Their salary wasn't adjusted until they ran out of grant money.
The argument is, actually, the provision is different than that.
Go ahead.
The provision is sufficiently attractive.
Well, there's 2 provisions. Read the economic one says sufficiently what?
I'll do it. A sufficient degree of economic security to make the profession attractive to men and women of ability.
So it's not the negative. It's not that it has to be unattractive. The question is whether or not
Sufficient degree of economic security.
Your Honor, whether or not, I don't think it's ambiguous, whether or not someone who is applying for tenure is being told, we're going to give you this job, okay, which is what happened. Full-time for life, no funding obligations. That's what this contract is. There's nothing in the agreement
Where
that
does the contract say that?
the contract letters do not reflect the obligation to raise funds.
Right, but that's again not the negative.
But it doesn't, but Your
You're
Honor,
quibbling about the negative
let's
of
take
this.
it out, let's take
All
it
they
first.
say is you have tenure.
Yeah.
No, let's take it out of the context.
Right? When they got those letters, it said you are a tenured professor. Congratulations.
Right.
And
And what does that mean?
And then I take it means those 3 norms those 3 norms provide the background.
The standard is,
Academic freedom, an expectation of continued employment, and sufficient economic security that people of intelligence will stay as professors.
not stay, be attracted to it.
Right.
Okay, that's different.
Right.
How are we going to bring people in? How are we going to make tenure something that attracts people?
But
Okay.
what definition of attractive only means
We can define what
come?
isn't attractive. I can't define what free speech is. I can define what it isn't. If someone tells me I'm not free to say something, then I don't have free speech. And the situation here is precisely the same. If I have
You have free speech. Again, this relates to another issue I've got, which is these are med school professors, they're not French literature professors or even people who work with computers who don't occupy, wet lab space. These are a different group of people.
tenure is university-wide. There's not tenure doesn't mean tenure for different people. It can't.
You don't think there's a difference, because all these provisions apply to lab scientists, right?
Yes,
They don't apply to the person teaching French or
agreed,
the person teaching computer science.
agreed.
In other words, research is central to the whole model.
Research is one of the three things that are required of a professor, and they're all equal. It's a three-legged bar stool. You have research, you have service to the community, and you have teaching.
Let me ask
What they
you
did in
about-
this instance is they elevated research to a point that if you don't comply with their fundraising obligations, even if you're an excellent teacher and an excellent member of the academic community, you get fired, or at least you can be referred for
Let me
termination.
ask you this,
Yes, sir.
if I have your argument right in its simplest terms for the word academic freedom not being ambiguous. Are you saying that that you can't have academic freedom if you're so limited in the type of grants that you can apply for? Because you have to go for the big bucks with the
saying exactly that.
NIH,
Yes.
and that's a limited type of pool. And so therefore, is your unambiguous argument that because you're limited to that, you don't really have academic freedom?
I am saying exactly that if you take the full panoply of potential research and you say you make sure that you focus on the 65% ICR research, or else if you don't support half your salary, which is a challenging standard, you have to apply put in a lot of applications for that.
Can they take away your lab? Or, I mean, if you're
Yeah.
studying something that has no financial remuneration and you're occupying lab space,
Yes.
they can take away your lab?
No, not
so
for
they-
failing to meet a fundraising
So when you
obligation.
get tenure, you not only are guaranteed your salary, but you're guaranteed a lot of lab space too.
No,
What
not
do you get?
guaranteed a lot of lab space. These professors got lab space as part of their job responsibilities, just like Dr.
So
Halaki
when
did in
they
the
got the
Stewart
lab
case.
space 50 years ago, they get to keep that lab space forever?
As long as they're doing their research, they should have a place to do their research. Yes, that is an
And what about,
inextricable
what about all the
aspect
younger
of tenure.
all the younger professors who need lab space to do the kind of knowledge-based research that people want done? Those people are out of luck?
I don't see anything in the record that suggests that the lack of lab space was the issue going on here. It's evident that what's going on here is it's a punitive measure done to convince people to focus their efforts on research that generates the highest ICR. Let me read, just because I think it makes sense to understand what academic freedom means to Tufts, at least the limitations thereon. I asked Thomas Malone, who is the 30B6 witness and the school's executive dean, this question. Does Tufts believe it has the right to impact academic freedom, even a little bit, in plans that it establishes and policies it puts in place? And the answer is no, not even a little bit. So if we're talking about a policy
I don't know
that
who this person is.
he was the 30B6 witness and the person who just,
We're looking at contract language, right? And
he's explaining what Tufts says the contract means. This is the meeting of the minds.
assume he's going to stand up and say, the president of Tufts said this, and there are 18 other people who've qualified this. And
There are three other areas in the transcript, all of which are there are three 30B6 witnesses. Three witnesses testified the same way, that any impact on academic freedom violates the after policy, which makes perfect sense, by the way.
And when we read this deposition transcript, we're going to hear that he's saying that if you in any way impact my lab space or make me do research that basically I get reimbursed for, that's an interference with academic freedom at Tufts, and we agree with that? I'll be flabbergasted.
They're not going to admit that, Your Honor. The
Well,
real
that's-
question is what this court can understand just as a practical matter, frankly, by judicial notice on some level. If I have a universe,
But I mean,
of-
so you're citing to deposition testimony, 30B6 testimony. And again, I go back to my first question is I don't look at that unless the term is ambiguous. And your position in your brief is that it's not ambiguous.
well, Your Honor, because the way that it's defined in academia, just like free speech is defined under constitutional law, we know what it is. It is the freedom to pursue whatever your heart desires. It may sound counterintuitive. It may sound
No,
like
it
a
doesn't
strange
sound
argument.
counterintuitive. It's just that you're citing to me things that require me to conclude that the term is ambiguous. And it's contrary to the position that you took in your brief.
Well, this court views this de novo. So even if the provision is ambiguous, the question is whether or not it can be resolved on the record before the court. And the answer is it can be, because there's no real debate that tenure is a full-time job. This novel idea that we can take
That was my other question. Are you asking us to vacate the lower court decision, or are you asking us to affirm summary judgment on your behalf?
I believe summary judgment in favor of the professors is merited on the record. This is a question of law, fundamentally. And the question is, well, I've proposed the questions. But the idea that Tufts can take a full-time position, and there can be no question that this is, I am a professor. My obligations are not just research. I have to teach, I have to be part of the community. In fact, the 2017 compensation policy says exactly that. In the area where it says we can cut you down to half-time,
We're going to ask your brother those questions, but your view is they can't do anything. They can't touch your lab space. They can't change your salary. They can't change your status in any way. You were tenured, and that's for life.
They may not do that.
I just want to make sure, am I accurately describing your position?
You're missing everything after the comma.
Go ahead. But tell me what they can do. What can they do to someone who is not bringing in money? Nothing?
Well, first question is are they required to? And you're going to have to struggle with that question because the answer is no.
I would just love an answer to the question of
What can they do?
What can you do to a tenured medical school professor, not who's sexually harassing someone who there's for cause for termination, and not whose department is studying something that no one does anymore? But what can you do to a professor who's tenured, who no longer is bringing in money to support their lab? That's just
what you can do, Your Honor, is number one, you can refer that person to the Tenure Revocation Committee, and that process, which is described and contractually mandated, can be undertaken.
That's for the for-cause discipline, right?
That's what we're talking about.
So you're
You can be
saying that-
disciplined for cause. And if this is
You're saying that when someone becomes basically a scholar who can't generate money, a med school professor, their only way of impacting them is through the for-cause disciplinary process. And I'm not saying that critically, I'm just asking. Is that
yes,
your view?
retrospectively, that's true because that's what the contract is. Prospectively, they can do whatever they want. I mean, there's the point. If we want to redefine what tenure is by putting in policies that require fundraising and that impose tenure revocation for not raising funds, they can do that. What they can't do is unilaterally modify the contract to impose those obligations retrospectively. That's what we're arguing here. So there's two things that can happen. They can be referred for tenure revocation, and then their peers will
Again,
decide.
and we're going around, and I'm sure the chief is going to cut this off, but the letter of tenure provides them with tenure, then we're directed to the AARP principles and other things, because none of this is in their tenure letter, right? They didn't sign a contract saying, when you become tenured, you will be a full-time employee with your salary forever and lab space forever. That was not in the contract. We need to dig through the AARP principles and other things to determine what that original contract was, right?
Yes, the original contract, Your Honor, I don't think there's much debate on this, or is this. I never should say that. Strike that, there's not much debate. The original contract was comprised of their award letters. We're also comprised of the policies that were in place at the time that described what tenure was. One of those policies was the basic science policy, and one of those policies was the after policy. Under the basic science policy, as my brother will tell you, the school has an expectation, a term that appears throughout that they use synonymously with a demand, but let's just say it. They have an expectation that you be an independent researcher. Tufts has taken that term of independent researcher and has said, well, it must mean financially independent. When if you look at the context, really what it means is, consistent with academic freedom, you must have independent thought. You must do your own independent research. You must come to your independent ideas and then pursue them. You can't be someone else's lab partner. You've got to have your own idea. Every one of my professors falls into that category. I've got Dr. Soto, for example, okay, who discovered the correlation between PBAs in plastics and birth injuries. There were warnings all over the world because of her research. Unfunded. Too basic for NIH. That's what we're risking here. okay? Because if we have a policy in place that schools can say, look, we're going to turn you into little revenue generators, like my son's MathWorks might, or any other biotech company that hires an employee, right?
No.
Okay.
Excuse
All
me.
right, thank you.
Thank you.
Turn you on.
May it please the court, my name is Darrell Lapp and I represent the trustees of Tufts College. The Superior Court got it right.
Yeah, I'm not 100% sure of that, but can you tell us what can you do? What can't you do to it? Under your view, what does tenure mean? I'm just trying to understand what it is.
What tenure means is what it says in the Academic Freedom, Tenure, and Retirement Policy, which is one of the documents that the parties agree is part of the plaintiff's employment contract. And what that document says is that when you achieve tenure, you have achieved a continuous appointment that is a lifetime appointment, which can be terminated only for certain specified reasons: cause, financial exigency, program discontinuance, resignation, or retirement. That is what tenure
Well, hold it,
means.
there's three components to tenure, right? Bear with me for a second, because your briefs are very good. We understand sort of the basics of your position, but so there are three components to tenure. One is just what you said, continuous employment. You're no longer an assistant professor who they can get rid of it at the end of the year. Two, you have sufficient economic security, whatever that vague language is. And three, you have academic freedom. You get to pursue, you're not going to be punished because you're studying something controversial. You're studying stem cells, you're not going to be punished because you're doing that because the Board of Trustees doesn't like that. But can you reduce their salary to $3 under your view?
It would not be a violation of the tenure policy to do
Really?
so.
I mean, so that all those thousands of professors in Massachusetts who are tenured under these AARP principles, your view is that they can reduce everybody to $4. The French professors, the computer scientists, tenure just means you get to stay, but for nothing?
Well, a couple of things.
Go
First of
ahead.
all, Your Honor, please,
Well, but that's the question. You said they can reduce it to $3, right?
I'm saying it would not be a violation of the tenure policy to do that. The rights that one has as a tenured faculty member are whatever rights you have as a matter of contract. We've cited case after case.
But the tenure norms are part of that contract, aren't they?
Not where the parties agree, and they agreed until this morning, that the contract is unambiguous. Whereas here, the parties are in agreement.
But that's a legal determination.
guys
And
can
so,
decide that.
well, you guys can agree to whatever you want to. I'm looking at these words and I'm thinking as a legal matter, I don't know exactly the contours of what academic freedom are, nor do I understand what academic freedom is in the context of economic security, which you agree are part of the contract that your clients made with their clients.
I agree, Your Honor, that the relevant provisions of the AFTR policy are part of the contract. The first part of Justice Kafker's trifecta is a part of the contract, a contract of continuous employment. The second part, academic freedom, is not inherent in tenure. The academic freedom,
Really?
all faculty at Tufts enjoy academic freedom. This is not just a tenure policy, it's the academic freedom, tenure, and retirement policy, some provisions of which are specific to tenure.
You're not really arguing that tenure doesn't include academic freedom, because if you're gutting, the entire conception of tenure, if that's the case, right?
I am not disputing that tenured faculty, like other faculty at Tufts, enjoy a promise of academic freedom. What that promise is, we answer
But
by
there's
looking.
unlike the other faculty members, those assistant professors or adjunct professors, they can get rid of at will. Or at least they can get rid of subject to these very limited contractual protections they have. But tenured professors are different. And if academic freedom has no role for them, I don't, all those corks that were popped in error. The same thing with,
Wait, I'm sorry.
yeah, go ahead.
Are you saying academic freedom is not the exclusive provenance of the tenured professors?
That is it,
That it applies
yes.
to them as well as to others?
Yes.
Okay, so it's part of the contract.
Academic freedom is a promise that Tufts makes to all of its faculty.
Right, another
not-
word for
not-
promise is a contract. So we
Yes.
have an agreement of the minds that you've promised academic freedom.
And what is the contour of that promise? We have made a promise of academic freedom. That promise is not, as my brother would have it, academic freedom means being able to do whatever you want to do. To answer the question, what promise of academic freedom did we make? We look to the policy, and what it says is academic freedom applies to teaching and research. It's important. You enjoy it subject to the adequate performance of your other duties, a point my brother neglects to mention. And it provides that when a teacher speaks or writes as a citizen, not on behalf of the institution, they should be free from institutional censorship or discipline.
But
That
these-
is what the contract
but
says.
none
That is
of
the
these-
promise of academic freedom.
But, yes, and I get that he's overstating what it guarantees, but it does, they have the ability to do research. I don't know, it seems to me that the fight here is not over academic freedom, although they're trying to link it to that, but economic security and continuous employment, which are two other components of being a tenured professor.
As to the third part of Your Honor's trifecta, we say two things. First of all, the language in the policy about economic security is not of contractual effect. It is a prefatory,
Yeah.
Why?
Statement.
Can you explain that?
because it's not a specific promise. This is a contract case.
Yes.
The plaintiffs are here saying, we are here to enforce contractual promises under our employment agreements, which include the AFTR policy. Well, let's ask the question. Does the AFTR policy include a contractually binding promise about economic security? Other courts that have reached this issue have said no, as did the Superior Court,
The New
because
York court does, and it's heavily criticized. The other, sometimes people they can define tenure, that economic security, and redefine it in the contract, but it's a background norm for us to give meaning to this.
this is not a case for the application of background norms. It is a
Really?
case for the interpretation. The court should respectfully follow the clear principles of Massachusetts contract law, interpret the contract language,
Okay, but we're gonna
not
do that though. But that language is in the, by the way, the contract you both point to is the letter. The letter references tenure. And then the only references to tenure that we have to draw on, which are in every faculty tenure around the country, is this principle. So we can't just ignore it and treat it as prefatory the way the trial court did, because it's language and it's clearly important. It may be too ambiguous to give meaning to, but it's not prefatory. It's a part of the contract.
it is prefatory, and it is more importantly too ambiguous to give meaning to, as other courts have held. And if it has any meaning, as the trial court found, and as other courts around the country have found, it is a reference to the one form of economic security that is actually referenced in the contract, which is continuous employment. There's
what is-
nothing.
What is continuous employment if you're going to pay somebody $3?
Well, nobody's being paid $3.
No,
There's
but you know, that's the hypothetical. That's the extreme, right? Or nothing, you know.
What about the half FTE? That's not continuous employment, is it?
It is continuous employment.
But you-
All of
it's
these-
It's just not getting paid.
As my brother has said, there were 3 dimensions to these folks' jobs: research, teaching, and service. They aren't doing half of their job. Thus, it's fully consistent with their contract rights.
What
to
do you say they're not doing half of their job?
They're not succeeding in the role of
And
being.
isn't the remedy to revoke tenure?
Tufts could do that. It also has every right under the party's contract to adjust their salaries pursuant to policies that Tufts had every ability and right to introduce. There's nothing about the plaintiff's employment contracts that says Tufts cannot adopt new policies that apply to tenured faculty after the moment they're
But
granted
I guess I'm trying
tenure.
to figure out what the limits of Tufts' flexibility are.
The limit, Your Honor, is that Tufts cannot violate any specific promise that it has made.
So
And
if
what
they
my-
made a promise of academic freedom, and the policy is you have to bring in this much revenue, and if the practical reality is that the only way you're going to be able to do that is with the NIH, and so your pool of research is limited, then why doesn't that violate the contractual agreement for academic freedom?
Several reasons, Your Honor. First of all, the promise of academic freedom is that you have freedom in research and teaching. You have full freedom in research, subject to the adequate performance of your other duties. It's not that you get to do whatever you
All
want.
right, so you're a rock star professor, and you're at all the community cocktail parties with the students. You're a rock star community professor, and you're doing really important research that's interesting, but the NIH is no interest, and you're not reaching the 65%. Why doesn't that violate the academic freedom contractual agreement?
Because your duties include not only teaching and not only service, but also maintaining an independent lab, being an independent researcher, doing meaningful science, one measure of which is peer review and external funding. The plaintiffs in this case all agree, there is no dispute of fact, that when they became basic science faculty at Tufts, they understood
So
that
independent-
generating external funding was a central part of their
So
jobs.
independent that you quibble about means either self-funded or, as counsel says, on your own, basically.
Well,
Do we have any context of who's right? I know shockingly, you're gonna say you are, but tell us what the record supports and what the case law supports.
in
on the
our brief,
independent.
we've cited specifically to the deposition testimony of the plaintiffs, who all understood and agreed on this point. For example, Dr. Yee testified that when she applied to Tufts, she understood that there was an expectation she would be successful in generating grant funds to support her research, and that to be an independent investigator requires generating sufficient funding to support the research in her
But I'm
lab.
sure you're going to read us other portions of depositions that say similar things, but my question again is, what are the limits on Tufts' ability to do that? And why hasn't this exceeded that limit? Making somebody a half FTE, reducing their, making them responsible for half of their salary, all of those things. What's my metric? Right? Dr. Yee doesn't say this is okay. She's suing your client because she thinks it's not.
Of course.
And she said, I did great research for 30 years, and I'm in a dry spell. Therefore, you're gonna wipe me out?
Well, Dr. Yee's been in a dry spell since 2014.
But that's their argument.
Well, the limit is that Tufts cannot breach any specific promise that it has made. And it has never made the,
But I'm confused by that.
That's the
because
sort of
original-
definition of breach of contract.
The original contract, you say, is pretty vague. You have tenure. And let me pose a hypothetical. So Tufts decides they want their liberal arts faculty to publish at Oxford University Press. And, Oklahoma University Press is no longer good. They're working hard, but they're not getting picked by Oxford. Can they become half-time employees too if you choose to do that? Because the tenure has no limitation on it? Why not?
the hypothetical is
The
that if someone.
hypothetical is now we're shifting out of, because both of you seem to say that med school doesn't matter. That tenure in medical school is similar to tenure in undergraduate. Maybe I'm misreading the briefs. But I'm asking you, if Tufts president passes a new policy that says I want my liberal arts people to be publishing in only the best publishing houses. They've got to get Oxford or whatever it is these days. If you don't publish there, I'm going to reduce you to a 50% employee. Is that okay?
I would actually say that that does not violate any promise of academic freedom that Tufts has
Does
made.
it violate the economic security for provision and the continuous employment provision?
It does not, because in the
Wow.
in the hypothetical, we haven't taken away anyone's job.
Tenure to you is, what is it limited? It's limited to full-time employment, but nothing to do with your salary. And it really, and what else do you get? You get to study whatever you want, but you don't have any promise of compensation.
You do
Is
not
that-
have any promise of compensation. Court after court after court.
I
has-
read those cases carefully. They're much more fact-specific and contractual language specific. They all a couple do what you say. The New York court says it's prefatory. The DC Circuit, Judge Skelly Wright says these are norms we have to provide meaning on. Some of the other courts do something similar.
I submit, Your Honor, that the cases are consistent in two fundamental principles. They are consistent in the principle that absent a specific promise, it is not a contract violation for a university to change a tenured faculty member's compensation or lab space. It's a contract case, and the plaintiff has to prove that they have a contractual promise that those things won't happen to them, and absent a specific promise, they have no contract claim. The cases are consistent on that point. The cases are also
What
consistent on...
cases do you rely on? The lab space I see is a totally different issue. What cases say that you can, besides the cases that say, when they gave you your tenure letter, like the case out of Illinois, when they gave the person a tenure letter that says, you have a guaranteed salary of $1, that's one case that they were careful, that university, to do that. No
These-
one else seems to do that.
The cases that we rely on are at pages 32 to 34 of
I
our
read
brief.
every one of them. Which case does what you want, which says you can reduce a faculty member's salary who has tenure to $1?
There's not a $1 case in the same way that Tufts has not reduced anybody's salary to $1. The lowest salary of any of the plaintiffs is $77,000.
So that's my question again. What's the limit?
The limit would be any reduction that is commensurate with a faculty member's failure to do the job that qualified them to get tenure.
But what about
Here,
the
we
economic
have,
security. I'm just confused about how, sounds like tenure's not such a great deal at
At least
Tufts.
not at Tufts.
with all respect, I represent a lot of universities, and I'm confident they would all take this position. Tenure is important. But what tenure consists of, what it gets you, is defined by what is in the tenure policy of the university. It's not some abstract, overarching principle. It's not a philosophical exercise. It is sure not what the AAUP says it means. It's what the contract says. And
But
what Tufts...
what is economic security, though, to your client? I don't understand how it can be
We
$77.
have, as just about every university does, we have quoted from introductory language in that 1940 statement, which mentions why tenure in some respects is desirable. Tenure is a good thing because it can be a means to economic security. Is that a contractual promise or a prefatory ambiguous statement? It is the latter. There is nothing in that language that says anything about salary, much less a...
What do you get? I thought that you got academic freedom, economic security,
And full-time employment.
and full-time, no.
You have to, you don't get full-time employment.
Lifetime employment.
You get lifetime employment, subject to termination for the 5 reasons that we mentioned. And like other faculty, you enjoy academic freedom, the contours of which are you get freedom in research subject to doing the rest of your job, And you aren't going to be censored for things that you say.
Heard that. What about the the economic security part?
There is not, our position is clear. There is not a contractual, tenure does not come with a contractual promise of economic
So
security.
the contract is the letter plus the handbook.
The plaintiff's employment contract, and I think we actually agree on this, the plaintiff's employment contract comprises their appointment and promotion letters and the relevant provisions of the faculty handbook, which includes the university's AFTR policy and the basic science policy, which is another important part of the contract, which makes clear the centrality of being an independent researcher to the very jobs that these plaintiffs hold. And all Tufts has done is to enact a policy that says if you don't do a fundamental aspect of your job, that can have consequences in terms of compensation and lab
That
space.
is a neat encapsulation. Is that in the language, by the way? That if you don't do the fundamental, I take it, we could interpret you and say you win because a fundamental aspect of a medical school professor is to generate enough income to support their labs. And if they're not doing that, we can reduce their lab space and their compensation. I take it that's whole different from a lot of other things you're arguing. That seems more reasonable. But where do we find this fundamental and how it's defined anywhere? Or you just, is that your sort of gloss on this?
No, if you look at the basic science policy, which is a part of the party's contract, it makes clear the centrality of being an independent, impactful researcher as fundamental to an initial appointment in basic science faculty, any promotion in the basic science faculty, and the award of tenure in the basic
Is
science
there an equivalent
faculty.
because we're writing a tenure decision. Maybe we only have to analyze it in the medical school context. But is there an equivalent on the other side of the, university lawn for the humanities and math and other things? Or, because I'm just worried that your description of what is fundamental is hard to define on the humanities side.
Each school has their own criteria for appointment, promotion, and tenure. It's obviously going to differ in some humanities
The
departments.
standards for promotion and tenure are clear. It's the consequences that you seem to be fighting over. To be a tenured professor, I bet you two agree that you need to be a distinguished blankety blank. It's the consequences of what happens after you get tenure that you're fighting about.
That's exactly right. And the premise of the plaintiff's case is that if you stop doing the job that justified the award of tenure, there can be no consequence for that without it being a violation of academic freedom or this amorphous language about economic security, which says nothing about salary or lab space or FTE status or the like. Our position is this is a contract case. It's not a
I think
philosophical.
his position's a little different. He says, if you don't live up to your obligations, you have an option, which is this for-cause termination provision, which generally applies if you're doing bad things as opposed to not being as good a researcher as you were before. But they're saying that's your only option. You're saying I got this whole other option, which is I can do whatever I want if I don't think you're living up to what got you tenure.
The university can adopt policies that apply to tenured faculty and other employees so long as those policies do not violate any promise that was made. That is, and in that regard, universities are no different from any other employer. Employers change their policies.
Tenure doesn't exist anywhere else in the world except
Well-
for maybe the judiciary.
I have a form of tenure as an equity partner in a law firm.
Yeah, I bet you don't.
Yeah,
Well,
I bet you
it's-
don't.
I bet you don't. And
Well-
you know you don't.
Well, I'm trying to illustrate a point.
But I don't think you're making the point you think you're making.
Well, if I came to you and said the firm is violating my contract rights as a partner because they reduced my compensation, the first thing the court would say is, well, what does the partnership agreement say? We would look to,
I bet it says expressly we can reduce your compensation, and this doesn't say that.
you would, if I was claiming a breach of contract, we're on the same page in this regard, Your Honor. You doubt that my partnership agreement includes protection for me against compensation reduction, and you'd be right. And our position is, this is a contract. They say, until today, it's an unambiguous contract. So we look to the language of that contract. We don't import terms that the parties have not expressed. Is there a promise? Is there a guarantee that salary, lab space, FTE status would never be reduced? Just like that kind of promise isn't in my partnership agreement, that promise is not in their employment contract with
So you're
Tufts.
saying tenure's like anything else, and that's your position, that's fine. It's okay.
It is my position, Your Honor.
Okay.
As court after court has said, the meaning of tenure is found in the tenure contract. It's not found in space. It's not found abstractly, and it's not found in
In
what
industry practices and
in
norms.
industry practices, unless, and there's a couple cases like this. This point is developed in our opposition, not our opposition, our response to the amici filings, unless the institution has stipulated to the application of AAUP's pronouncements.
Or cross-reference them in the contractual document.
No, Your Honor, please, not, with all respect, not that simple reference to the 1940 general principles, but has actually adopted the AAUP's statements as a whole. That has not happened here.